Welcome back. You're watching HFO-TV, co-sponsored by AMF Capital, the Baljanik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. Today we're lucky to have with us Brad Kraus again from Warner Allen Attorneys. They are a law firm that specializes in landlord-tenant law. We've used them a lot and referred a lot of clients to them in terms of when we've got property owners that have things they want to work through, especially in the times that we're in today. We highly advise, getting legal advice on some of these issues. So Brad, I want to thank you for taking the time. I hope you and the family are safe. And let's talk about some of the changes or the nuances between kind of Oregon and Washington with these eviction moratorium notices from the governor.
Thanks for having me. I appreciate being here, and hopefully everybody out there is staying healthy, staying safe, because it's getting to be another storm coming, I guess. So
it's feeling that way. So I know you guys do stuff on both sides of the river in Oregon and Washington. Maybe give a little insight, because again, our audience is similar as well, Pacific Northwest, so it covers both. There are some differences with kind of the proclamations that have been put out, states of emergency, and how that affects landlord-tenant law. Maybe give a rundown of the Washington, then we can jump into Oregon as well.
Yeah, so the Washington proclamation, Inslee's proclamation, is, I guess, just to summarize, it's much more restrictive than Oregon's restrictions are, just because of the conduct-based restrictions in terms of notices. And what I mean by that is, in Washington, obviously, if you have a tenant that is not complying with the lease, in normal times, you'd serve them a 10-day notice, 10-day
right.
Comply or quit. In Washington, you can't do that anymore unless the conduct and the landlord attaches an affidavit to the notice, which says that the action is necessary to respond to a significant and immediate risk to the health, safety, or property of others. And so when you think about a lot of things that you would serve a 10-day for, think about unauthorized guests, noise, partying, things like that. Do those things really rise to that level? I guarantee tenants attorneys are arguing that they don't. And from a landlord's perspective, even I don't know that they do. That's a pretty high bar.
So this is on, Brad, this is on the eviction moratorium. So we're not talking the financial eviction, the financial moratorium on evictions is still in place. This is, as we've talked about before, I think last time we were here, there are some, people that are tenants that are needing to be, taken out of buildings due to, various issues. And you're saying in Washington, it's much tougher because of this burden of.
It's much tougher because of the affidavit requirement and what you have to basically show. And so that's a problem for Washington landlords. Whereas in Oregon, conduct-based notices are still viable. So then there's no affidavit requirement in Oregon. So if you've got a tenant that is partying, making noise, disrupting the quiet use and peaceful enjoyment of others, you can serve a for-cause notice for that without, having to worry about any sort of moratorium being in place.
Gotcha. Okay. And then the timing on both of these, we discussed this before. I mean, I think it was what you were saying, like one's kind of open-ended, one's kind of set. Now, again, we're recording this now. It may be extended out. We don't know that. But as of right now, what's your understanding of the timing of when this moratorium?
Yeah, so the open-ended piece, that would be the Multnomah County one, and I'll touch on that in a second. But both Washington and Oregon statewide, their eviction moratoria / proclamation, depending on your jurisdiction, both of those are set to end at the end of the year. So Governor Brown's executive order is kind of the operative eviction moratorium right now. Governor Brown's executive order 20-56. That expires at the end of the year. Inslee's proclamation is scheduled to run and end at the end of the year, but obviously who knows if those will be extended. The key point is that if you have property in Multnomah County, Multnomah County's moratoria is a bit more open-ended just because of their moratoria is scheduled to end on January 8th or whenever the emergency declaration ends, whichever is later. And so we really don't know when that is. Obviously, it's unfortunate, but I could certainly see Multnomah County extending things, even if the state of Oregon does not, just simply because that's what Multnomah County does.
So in Multnomah County, it's tied to the governor where the state of emergency is to when it's not a hard date.
Yeah, so Multnomah County is they have a set January 8th date for the end, or whenever the state of or the declaration of emergency ends, whichever is later. And obviously, as you can imagine, the emergency is probably going to last beyond that January 8th day. So, you know, unfortunately, that has some practical effects for not only when this stuff ends, but also the grace period in terms of the rent that's due. Multnomah counties will extend beyond the March 31st date that the state sort of grace period will hopefully end.
Got it. Okay, so we're kind of up in the air on that still as we okay. And then I know what kind of, you know, I had kind of an interesting conversation with somebody about, you know, a tenant's in, and you know, almost, you know, the existing tenant moved out, but then there was people in there, you know, not on the lease. I mean, they ended up, you know, quote, I don't want to say, you know, squatters, but I mean, what does a property owner do that in this time of COVID and these emergency declarations? Is there something? I mean, I'm sure your phone's ringing off the hook with various nuances to these things with these circumstances. So maybe shine some light on a couple of these odd ones.
Yeah, the squatter situation is interesting, and it's obviously picked up now since COVID came in. There is a particular statute in the Landlord-Tenant Act in Oregon, ORS 90.403. That's the unauthorized possessor statute, and effectively, the landlord only needs to be able to show three things in order to serve a 24-hour notice for an unauthorized possessor. So effectively, a notice directed at the squatter. What they need to be able to show is that the original tenant moved out. So typically you'll have a lease with an original tenant. That person moved out. The lease prohibits assignment, subletting, or anybody else living there, and that they haven't knowingly accepted rent from that person. People. Yep. Got it. And if they do that, and if they can show that, then a 24-hour notice for an unauthorized possessor is the way to go. Once that expires, you can still file an eviction based upon that notice in Oregon. And you know, what I hear a lot of times is these unauthorized possessors will say, you can't evict me until the end of the year. Yeah, unfortunately, that's not true. You know, a lot of people they misinterpret and don't really know, especially squatters, they don't want to hear that, I can actually evict you after 24 hours notice, because there's no prohibition on that in any moratoria. So. And
what about it? Is the same go in Washington with that? Or is that
the same? The Washington issue is a little bit different in that holdover tenants. This is sort of a clarification in the new proclamation. Holdover tenants, so persons not listed on the lease who remain or hold over after the tenants of record have permanently vacated the premises, may now be evicted unless the landlord has accepted partial or full payment of rent, including payment in the form of labor from the holdover occupant, or has formally or informally acknowledged the existence of a landlord-tenant relationship with the holdover occupant. It's a little bit of a unique wrinkle. I haven't had an opportunity to utilize it in Washington, but obviously, if that's a situation, people can give us a call and we can chat about it.
Okay. What kind of other things are you seeing kind of in the landlord-tenant law realm this year that maybe, you know, a little different than what, you know, was been pre-COVID?
Yeah, obviously, with COVID, you have more folks staying inside, right. You know, not doing anything. And when you have folks like that are kind of together all the time, obviously, tempers can flare, tension can rise. Have seen a couple of basically tenant-on-tenant, let's call it discrimination issues. And landlords should be aware that there is a particular Oregon administrative rule which deals with tenant-on-tenant harassment, tenant-on-tenant discrimination. And it says that the landlord can be liable for that tenant-on-tenant harassment if the landlord knew or should have known that it was occurring and failed to take immediate action. So let's say you have two tenants that live next to each other, and one of them says something, you know, racist or discriminatory directed at one of their tenants. What I advise my clients to do is take immediate action on that and to serve a notice, because the failure to do so can result in some exposure there. Okay. It is a fair housing issue. There's other jurisdictions around the country that have held, their courts have held that if the landlord doesn't take action based upon another tenant's discrimination of another tenant, that the landlord can face liability there. And I would much rather face a situation where my notice fails, you know, for lack of proof. If the judge says, well, this is a he said, she said situation, I'd rather have my notice fail and be able to say, yeah, I tried, than to do nothing and to potentially face a fair housing suit. You know, if a tenant decides that the landlord didn't do enough.
Because the property owner doesn't notice to the tenant that was doing that, there'll be some burden of proof on them at that point for that notice. But like you said, if they go through the act of actually doing the notice, at least they can look back and say, I did what I can do. You know, I can't be pulled in theory back later for something else.
Of course, and obviously, you know, racism, discrimination, things like that, those sorts of things should be stamped out anyway.
Right.
You know, they shouldn't have a place in the world, but you know, from a landlord's perspective, I care about the exposure that those sorts of things can also lead to my client. And obviously, you know, landlords also care about the living conditions that they're providing for their tenants, and tenants shouldn't have to put up with that either. So, you know, that burden does fall on the landlords, but again, taking that immediate action to serve a notice and to really kind of tamp that down, I think benefits everybody. And that's probably the purpose of the OAR.
And what, kind of going back to some of this eviction moratorium thing, what are you telling if you've got a tenant that's, you know, owes money to a property owner, they, for some reason, be it discrimination, for some reason are, you know, asked to leave the property, they were carrying this balance. I mean, are you advising the property owner to try to, I mean, is there an avenue to go after that? Is it kind of, you know, you're lucky what you can get? I mean, what are the options there, if any?
Yeah, it's interesting, and this is sort of it's a source of dispute amongst attorneys here. There's not a consensus, but the question really becomes, do former tenants get the benefit of that grace period, right? So let's say you have a tenant that owes you some money. You know, if they leave, you know, can you immediately sort of go after that debt and sue them for that? And it's an unanswered question. And it's one that if you take the approach and you take the position that former tenants don't get the benefit of that, you know, there is some risk there because nobody knows. Okay. You know, what I've been telling folks is the conservative approach, and the approach that I know is not going to get you sued for violating any sort of moratorium, is to wait until that grace period ends to then file suit. And I understand that's problematic for some landlords, and it just kind of is what it is. But the statute of limitations was told in House Bill 4213 and in the Multnomah County moratorium as well. So it's not as if the statute of limbs, which is normally 1 year in Oregon, it's not as if that's going to run out. So you're not going to run out of time. Oh,
so they extended out the statute of moratorium on that specific component of it. I got it.
Yep. So you're not going to be barred by a statute of limitations. If you normally would sit on it in normal times, you might face that issue. But again, that is a risk assessment that landlords make. I wish I had a definite answer as to that question, but I simply don't. And I've heard it argued competently on both sides, which is the interesting thing. So.
But I mean, we're doing this here in mid-November. I mean, I think right now it's through March. So, I mean, by the time this gets out, I mean, it'll be close. Again, that's assuming we're not having some extension. You know, then we start having discussions about, you know, how long of is an extension, and when is there a property taking issue, and, you know, as property owners, you know, still have their mortgage due, still have their utilities, still trying to do maintenance, you know, how long can they continue to kick that down the road?
It will be super interesting, and a couple of different, you know, a couple of things just based upon that. I read an article recently on Yahoo from folks at, I think it's called the Motley Fool, I think is they're sort of an investment website.
Investing advisor group.
And I read an article, and they had said that if landlords aren't receiving rent, that they should stop or cut back on maintenance. And my answer to that is no, absolutely not. Just because there is a moratorium and there is COVID-19, you still have obligations under the Landlord-Tenant Act. So if you read something like that online that tells you simply because your tenant is not paying you rent or is affected by COVID or any of those other reasons that you should stop, you know, doing maintenance and taking care of the things that you need to take care of, don't listen to that because it is incorrect as a matter of law.
Because you're still under, life safety issues on buildings. Yeah, even though they're, yes.
And the other thing that you touched on, Greg, is at a certain point here, this stuff does really start to really hammer down on landlords. It obviously is right now.
Right.
I am aware of a lawsuit that was filed in Washington challenging Governor Inslee's proclamation. I can't remember the firm that did it, but it's challenging basically the rent, the restrictions on non-payment of rent notices and things like that. I'm not currently aware of anything like that in Oregon, but I would hope that if things continue, that such an avenue is being considered, because right now, again, small mom and pop landlords are in no better position to bear the brunt of COVID-19 pandemic moratoria than tenants are. I mean, they still have, like you said, mortgages to pay. Banks are not, banks still want their money. It's unfortunate that a lot of landlords are really being put in this position. But, it's not just tenants that are affected by these things. Landlords are too. And unfortunately, that's not really taken into account by some of the legislators.
Then I had a question about kind of a Portland in specific, where when they came out and said, this relocation fee, which again, there's a lawsuit going with that right now, and I think it's up for appeal, and they're still dealing with that. But, when they came out and said from the city of Portland, if you raise rent any amount, there's the relocation fee is due. Are you running into issues with property owners on that, or what are you advising on that?
Not really. The main issues that we were sort of running into were sort of the rescission notices that came about, right when everything kind of came to be. What we're seeing right now is a lot of landlords are simply holding off on rent increase notices just because, as we get towards the end of the year, nobody wants to run into a situation wherein, they're faced with another rent increase moratoria, and then they have to maybe rescind or face some exposure if they don't. So right now, a lot of my clients are simply holding off right now and kind of reevaluating at the end of the year. And it's really only about 45 more days until hopefully there's some clarity as to what's happening on that. So
okay. Well, Brad, I want to thank you for taking the time to kind of give an update. I'm sure we're going to be doing this a lot more often now as things change. And as you said, we've got these hard dates in some places. We don't have them in other places, and that may get extended as, we're all, dealing with this, locally, worldwide in this COVID pandemic, and nobody really knows how it's going to shake out. But I think the biggest I think note for owners is, get advice. It's not that it was ever easy to manage property anyway. Now there's some more nuance to it. So, don't, if in doubt, or even if you're even questioning, I recommend, call Warner Allen, call Brad, get some advice before you do this, because the damages and the punitive damages to property owner are much more severe. This is not like managing back in the, 70s and 80s. So
it's a different world. And when you take a look at some of the damages provisions, the best example I give is the Portland Ordinance. If you're not, if you don't include a notice of tenants' rights with some of the notices, that invokes the damages provision of the Portland Ordinance. And you see claims of $10,000 just for forgetting to include a piece of paper. And, the way I fight back on that in terms of pushback is, I don't really think the ordinance itself says the damages are up to 3 months of rent, relocation, plus all these other things. My position is, do you really think a trier of fact is going to, penalize landlords for what amounts to effectively failing to put a postage stamp on an envelope? It's sort of the same type of thing. But again, having to deal with that lawsuit is going to cost money. So, getting advice beforehand is, like you said, I think it's invaluable. And yep, it does take some attorney time and a little bit of cost, but a little bit of cost on the front end will save you a little bit. And
as we talked about before, making sure your forms are up to date, making sure you've got all the most recent, forms that you're using. And again, if in doubt, call an attorney. This is not like it was in the past. The punitive damages are big, and again, those may get negotiated down, but there's other attorneys that will take these cases, and like you said, dealing with the lawsuit itself, even if you were not in the wrong as a property owner, you still need to address this. So I appreciate you taking the time for this and educating the people out there. we'll do it again soon, and be safe. Thank you.
Always here. Take care, Greg.
We'll see you again next time on HFO TV. Thanks, Brad.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Call 503-241-5541 or visit our website at hfore.com for more information.